Hi, everybody. Today is June 21st, 2026. I've been posting these videos as a form of therapy in the recovery from watching my little brother, Paul Cairns, 64 with Down syndrome, be locked away by the British Columbia New Democratic Party government, David Eby as leader, Nikki Sharma as Attorney General, and Sheila Malcolmson as the minister responsible for Paul's care. So the government locked Paul away. We had visited at will. We grew up together. I'm only 2 years older than him. And I had cared for him at my home on weekends and holidays, along with my two sisters here in the lower mainland of British Columbia and my mother. Until my mother died in 2004, and then my sisters and I took over. But the government locked Paul away from me, his last surviving local family member and visitor, when I complained to the Burnaby RCMP police after I discovered a secret and what I alleged to be a fraudulent and forged power of attorney the government created to give Paul the COVID-19 shot in February of 2021. I didn't find out until 2022, and I complained to the police in August of 2022. And immediately after I complained to the police, the officer that I spoke with said that she was going to subpoena or get a search warrant for the original document that had Paul's so-called signature, his forged signature. But she didn't do that. What she did instead is she tipped off the group home where Paul lived to the fact that I had complained, and 10 days later they permanently terminated my visits with Paul. They said, you'll never see, their lawyer, the government lawyer said, you will never see your brother again. Paul was my last surviving family member and sibling in the lower mainland as well. I did everything on earth I could think of. I was formerly a psychologist for the government of BC working with mentally handicapped adults. Then I went to law school as the first single mother in history to graduate from law school in British Columbia. And I did that in part because I wanted to protect the rights of mentally handicapped, disabled adults. And I worked as a federal prosecutor for the government of Canada. That was my first job as a lawyer. And then I went into family law. I became a family lawyer, practiced family law for 23 years before I became disabled in an accident. So I did everything I could think of to try and restore Paul's visits. I complained to the British Columbia Human Rights Tribunal. They did nothing. They were ordered by the David Eby to slow walk my complaint, and they didn't contact me again until after Paul had passed away. So they locked Paul away in his group home for 588 days until I got a telephone call. They had appointed my 82-year-old Catholic nun sister 4,000 kilometers away in Ontario as Paul's guardian. She had never lived with Paul. She moved out of our home when he was born. She didn't understand his speech. He had a speech pathology or communication. She did not move him to be closer to her or move here to be closer to him. So he was left isolated and alone in the group home by the British Columbia government. All of this is as horrific as it sounds, and you really wouldn't believe it unless you'd lived through it. And it actually made things worse that I was trained as a psychologist and then as a lawyer and a prosecutor, because I could see how far this departed from the normal legal practices or acceptable legal practices. So on April 15th of 2024, I got a telephone call from the nun's lawyer. She had two law firms working for her around the clock, Charles Gibson in Ottawa and Borden Ladner Gervais with Casey Dean Shaw as her lawyer in Vancouver. And I got an email from her Vancouver lawyers on April 15th of 2024 saying Paul had had a stroke, but I could come and visit him. So they didn't mind me visiting him after he had a stroke, because the whole reason they had isolated and confined him away from me was so that I couldn't get an authentic sample of his signature. So they assumed that he couldn't sign anything after he had a stroke. I was allowed a 10-minute per day visit for him for the 10 days that he survived in the hospital. Paul, when I saw Paul, he grabbed my hand in the hospital after he had had the stroke, and he appeared to be recovering remarkably well. He sat up, he grabbed a book from my hand, drew the pages perfectly, scanned the pictures perfectly, made good eye contact, understood what I was saying. He had a ventilator and an oxygen mask on, so he couldn't speak, but he communicated as best he could, even though he couldn't speak. He was on some kind of intravenous. As the days wore on, he appeared to me to be sedated, over-sedated. There was no reason for him to be sedated at all because he was recovering from stroke and he was struggling very hard to do that. But I believe that my sister, who had flown in, after she could see that he wasn't going to die, she'd flown in from Ontario and moved him into a room where she and he were the only people allowed in that room, other than me at my 10-minute visits. So while Paul was in the hospital, I got a call from the Burnaby RCMP police staff sergeant saying that they were ordered by their Ottawa Oversight Agency to reopen the investigation. As I said, the constable that I had complained to about the fraudulent and forged power of attorney, just all she did was tip off the group home, and they terminated my visits with Paul. No, there was no investigation done at all, but they had been ordered by their Ottawa Oversight Agency, the Civilian Review and Complaints Commission for the RCMP, to reopen the investigation into the fraudulent and forged power of attorney. So I got that call and I was thrilled. I was so excited. I thought, finally, somebody's paying attention. Paul's going to have, his rights are going to be enforced. He won't be locked up the way that he has been by David Eby. And I went to court the next morning asking the judge who had conduct of the case to suspend the nun's guardianship of Paul pending the investigation by the RCMP. And we didn't get on. When I got back to the hospital room, the nun met me at the door, and she wouldn't look me in the eye. She avoided eye contact, which is a dead giveaway that somebody's lying. And she said to me through gritted teeth, "Say goodbye to Paul, he's dying." So I noticed that all of Paul's medical supports had been removed. His ventilator, oxygen mask had been removed. And I can't remember whether his intravenous was removed or not, but he wasn't attached to anything, and he appeared to me to be dead already, and I've seen dead people before. He was completely still, his eyes were wide open, and his pupils were dilated and fixed, and his hand was cool and completely still. So I think he had actually been killed. I believe that the nun told Paul's treating doctor, Michael Baker, who I've complained about to the coroner and to the College of Physicians and Surgeons, to do medical assistance in dying on Paul. So that is to sedate him to death. So the next day I got an email from the nun saying that Paul had died, but I could come and look at his body. After Paul died, the nun flew in again from Ontario, and both of her lawyers were there. I estimate that the Catholic Church spent more than $2 million. But she flew in from Ontario to have me designated permanently what's a very rare designation called a vexatious litigant, which takes away all of my access to the courts. So the access to Canadian courts that even a stranger from some non-citizen would have, I don't have. I cannot do anything. I can't even respond to a lawsuit against me without permission of a judge. And the judge who heard my sister's application, I presented 2 certificates from my family doctor and my cardiologist saying I couldn't appear in court for longer than 2 hours per day. But she said because I had said that I could care for my brother, that she didn't have to pay attention to those medical certificates. And she had her, the hearing took place over 2 full days. And at the end, of course, she designated me permanently a vexatious litigant, suspending all my access to Canadian courts. So that's where things stood. I've since applied to be reconsidered on the grounds that I was not there. I got up and left after the first 2 hours because that's what my physicians told me to do. So after all of this happened, I'd sort of been in a fog because I was trying so hard to restore Paul's civil rights. But I looked into this medical assistance in dying that's taken over Canada and dragged Canada down into a dystopian hell. And I thought, how on earth? I mean, I was a federal prosecutor. I sent people to prison. I sent important people to prison on a regular basis. And I thought, doctors can kill people. They can just kill people. Didn't make any sense to me in my training as a psychologist and my training as a lawyer and as a prosecutor. And what I discovered was that the Supreme Court of Canada had this issue come before it about 20 years ago in a case called Sue Rodriguez, Canada versus Sue Rodriguez, where a woman named Sue Rodriguez had been a member of parliament named Sven Robinson, who I know. I was actually at one point his election campaign manager. But anyways, he had promoted to have her killed by her doctor because she had multiple sclerosis. And the Supreme Court of Canada considered that case in full and said no, that was not in the public interest for doctors to be killing their patients. But in February of 2015, what I discovered is there was a new case that was promoted by a ghoulish death cult called Death with Dignity. And they put forward this woman named Kay Carter, who had spinal stenosis. So that's kind of a fusion of the spine. And she apparently wanted to be killed. And she'd actually gone to Switzerland and been killed by a doctor in Switzerland. But the Supreme Court of Canada, notwithstanding that Kay Carter was already dead, and therefore the case was moot. So there was not a live issue, literally a live issue before the court. They went ahead and they said that Kay Carter could be killed by a doctor. It wasn't fair to her to have to wait until she became terminally ill when she might not be able to kill herself. And they gave the Supreme Court of Canada 9 unelected judges, gave the government of Canada, they said it was her charter right under Section 7, the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So what they said was she had a charter right to be killed by a doctor. If you can imagine such a nonsensical, stupid conclusion arrived at and the Supreme Court of Canada, 9 unelected judges went against the Parliament of Canada, which had abolished capital punishment, hanging by the government of citizens for civilians in 1976 and for military staff in 1999. So throughout the time that I was working for the federal government as a prosecutor, I had the option. I could have brought charges and had the defendant hanged, although that never came up and I never did. But I did send people to prison for fairly long sentences. So what happened in February of 2015, as I said, Kay Carter was already dead, but the Supreme Court of Canada, which was led by the Chief Justice Beverly McLaughlin, who is a judge who worked her way up from the Court of Appeal of British Columbia, who I've met. I met her at a conference for women in the law. She was actually a hero of mine. So every hero of mine has been disgraced in this sad tale. So they anonymously and unanimously allowed Kay Carter to be killed by a doctor and gave Canada 12 months, 1 year, to come up with a system to safely and fairly and without breaching the charter rights of Canadian citizens have doctors kill Canadian citizens. And since that decision in February of 2015, Canada has executed extrajudicially by lethal injection more than 100,000 people. Now, I can tell you one thing. I was a divorce lawyer. So when I was practicing on my own, all I did was divorces. And 50% of the divorces that are submitted by anyone are rejected by the court as being having errors or typos or not enough information. But to my knowledge, not one of these 100,000 murders, what would have been murder before 2015, not one has been set aside by Canadian courts. It's as bad as what Hitler did as soon as he became chancellor in 1933. He went through all of the hospitals, sanatoriums, and he killed every elderly, disabled, and ill person in Germany. He called them useless mouths. Useless mouths. So he killed 350,000 people before World War II even started. And this is what in Canada has already, in the 11 years since February of 2015, Canada has killed more than 100,000 people. Canada kills 45 people every single day. They pay doctors to execute extrajudicially by lethal injection more than 45 people every single day. 5 out of every 100 deaths in Canada is caused by a doctor administering a lethal injection. 7.5 in Quebec. So, needless to say, I was completely shocked to find this out. What I discovered is that, and this is probably the most important point that I want to make, is that the Chief Justice who changed the law to turn first-degree murder into a government practice, a government-sponsored practice, Chief Justice Beverly McLaughlin, made that decision in February of 2015, and then she went to work for the communists. You will not believe this. I could not believe it. She then went to work for the Communist Party of China in Hong Kong for 6 years. I mean, she was old in 2015. So how much work she actually did for the Communist Party of China as a Court of Appeal judge. She worked for them from 2018 to 2024, which is completely, in my view, improper, irregular, and I believe a sign that she was a traitor, and her betrayal, and that her betrayal of Canada is in that decision, Canada versus Carter. And as a result, more than 100,000 innocent, vulnerable, already marginalized Canadians have died. They have no right to legal advice. All it takes is the signature of any two medical professionals, any doctor, any nurse, and that of the patient on a piece of paper. It's not a sworn affidavit. None of the guarantees that have been built up to protect citizens from the state since the Magna Carta in 1215, more than 800 years ago. British common law has developed all kinds of systems of protecting the individuals from the state. Every one is erased by this medical assistance in dying. The first thing I noticed about medical assistance in dying is the word medical is from the Greek word. Words are very important in law, and the word medical is from the Greek word to heal, and you don't heal anybody by killing them. So if you want an argument, if somebody says, oh, well, why should people have to suffer if they're not, it's their choice. It's like abortion. Well, the thing about abortion is the reason it was allowed was to protect the life of the person, the mother, so she shouldn't have to be a life support system for another person, and the state had an interest in that other person. So it was to protect the life of the mother, who was a person. And in Western civilization, a person is defined as an infant that takes its first breath. Since 200 years BC, before Christ was born, the definition of a person is someone who takes his first breath. So these people, these are persons that are being killed by the state in Canada at the rate of 45 a day. And there have been cases, as I've tried to show you, where people changed their mind, but my brother was killed right in front of me. He was murdered right in front of me. And the other point that I wanted, the argument that you can have when you're talking about this with people is that nobody can consent to being killed. You can't give informed consent to being killed because we don't know what death is. In my religion, you either go to hell or heaven or purgatory. Other people believe you just cease to exist. And probably the most popular opinion in the world is that of reincarnation. You come back as another animal or person, but nobody knows, so you cannot give informed consent. And actually, in my religion, if you consent to being killed, that's suicide. It's a mortal sin, and you go to hell, in my understanding. The second point to make is that the reason capital punishment was abolished is because it's permanent and irreversible. It's many decisions you make in life you can change. Death is not one of them. And finally, there's the logical fallacy of perfect implementation. So the Supreme Court of Canada gave Canada, the government, 12 months to come up with a perfect system of delivering this euthanasia in Canada, which in 40,000 years of human civilization, no one has ever been able to come up with a system that didn't address the issue of human frailty, greed. And for example, many of the people that are being executed extrajudicially by lethal injection, their organs are being harvested for elites. So that's it for today. Please do everything in your power to bring this horrific practice to an end, which undermines the sovereignty of Canada. That is the reason that Europe was invaded by the Allies, was because of Adolf Hitler's obsession with killing people. And these doctors that sign these papers, they like to kill people too. They can bury their mistakes. The worst mass murder in history in the Commonwealth was a medical doctor named Harold Shipman, and he killed 250 of his patients. And the worst female mass killer in history in Canada was a nurse named Elizabeth Wetlaufer, who killed 11 of her patients. So assigning life and death, making doctors and nurses judge, jury, and executioner wipes out 800 years of progress and protection of citizens in the Commonwealth under British common law. So that's it for now. Take care, everybody. I love you all.